Secondly, by nature, this means that such a distribution would be unjust, and you would be committing an injustice towards your heirs by distributing your inheritance in a way that is contrary to the laws of Allah. The Prophet ﷺ is narrated to have said that if any one of you has something to distribute, has something to leave to their heirs, they should not rest for 3 days without having a written will in place. So this tells you about the importance of having some instructions that you leave behind for your heirs and how your estate is to be distributed upon your death. Usually when in English we hear the word estate, we often think that this is referring to very wealthy people, people who leave behind a lot of wealth. However, as far as the Sharia is concerned, any amount of wealth or any possessions that you leave behind, this is part of your estate, and these need to be distributed according to the way that Allah has shown us in the Quran. Um, there are actually the laws of inheritance are some of the most detailed laws that Allah mentions in the Quran in Surah An-Nisa, where Allah details individual shares, and we will go over who one's heirs are, just so we all are aware of them. But the detailed shares that Allah mentions in those verses, such level of detail is actually not found in any other ruling of the Sharia that is mentioned in the Quran. So this should also tell us about the importance and significance of this. So for those who are, I don't know who is controlling the slides, but I am on the second slide here. What needs to happen upon someone's death, the very first thing that happens when somebody passes away, uh, is the entirety of their wealth, everything that they leave behind, is distributed into three parts. Or sorry, even before that, everything that you leave behind is part of your estate. And the very first thing that is going to happen with your estate upon your death is if there are burial expenses that need to be paid. So whatever this includes. So if this includes purchasing a grave, if this includes, paying for transportation, whatever this burial expenses, whatever they include, they will be covered from the deceased estate. And this is the first thing, even if this exhausts the entirety of one's estate. So let's say somebody leaves behind only $8,000 to $10,000, and this is what is required to bury this person. That is fine. We will use the entirety of this money to bury this person. The second thing that needs to be done with your estate is if the deceased has debt. So if the deceased has debt, then this person's debt will be paid from his estate. Now, a word of caution over here. So the debt that I am referring to is primarily a personal debt. So something that you owe someone. Long-term debt. So for example, if somebody has a mortgage on their home, then it is not required that the mortgage be paid off using this person's estate. Rather, usually if you co-own a property with somebody else, then they would have signed the mortgage agreement as well, and it would just transfer over to them. But it is not required, and there are details about this based on individual circumstances that perhaps we don't need to discuss in detail right now. But if this is your case, if somebody has passed away and they left behind a long-term debt, then you should seek the advice of a Muslim scholar who will tell you what needs to be done from the Sharia point of view with that debt. So of course, the legal point of view, my colleague will speak to that. But from the Sharia point of view, what needs to happen with that long-term debt? And the third, now, once these two things are done, the burial expenses and the debt is covered, then whatever remains of one's estate, you divide it into three, and from up to 1/3 of that of this division, it is permissible for the deceased to make a wasiyah. A wasiyah is a bequeathal, and this is it is permissible for one to give a portion of one's wealth, so long as it does not exceed 1/3, to anyone that they please, or any organization that they please, or any charitable cause that that appeals to them. The only two conditions that we put over here is, A, you cannot bequeath, or you cannot gift a portion of your estate to someone who is already receiving a portion. So, for example, this you cannot say that my eldest son should get this 1/3, because obviously what will happen if one were to do this is this would in effect, this is you are not following the laws of distribution if you are giving one heir more than their designated share. And the second thing that you cannot do is, obviously, you cannot bequeath to a haram cause, or you cannot contribute or gift this to something that is haram. Apart from this, you can give it to other members of your family who do not automatically inherit from you. For example, if you have if your father and your children, your male children are alive, then your siblings are not or even if just your male children are alive, your siblings are not entitled to inherit from you. But if you wish to gift them something from this 1/3, then that is permissible to do. It's also permissible to give this to a charity. For example, you can give this to the masjid, or to give this to some other charity. It doesn't need to be the entire 1/3. It can be given to several places or people, as long as the sum total of that does not exceed 1/3. So this is what happens immediately upon your death. I am on slide number 3, so if we can move the slide, inshallah. As far as the Sharia is concerned, there are three types of heirs. The first is Dhawil Furud, so these are sharers. What this refers to is, these are those individuals that are named by Allah subhanahu wa ta'ala inside the Quran. Number two are residuaries. So residuaries are those individuals who get, sometimes they are entitled to a share, and they are also entitled to any remaining balance that is left behind after the estate is distributed. And number three are distant kindred relatives. So these are people who are only entitled to a share of the inheritance if in the absence of the first two categories. So if there is nobody from Dhawil Furud, the first category, the sharers, and there are no residuaries, then and only then will the distant kindred they will receive a share of the inheritance. And you don't need to really remember all of this. I'm just going through it so that you are aware of who actually is entitled to a share of your inheritance, and we will list them, inshallah. So if we can move the slide ahead. These, what you see in front of you, these are the Dhawil Furud. So these are those individuals who have a fixed share, and this is mentioned in the Quran. So the father, mother, husband, wife, daughter, full sister, uterine brother, uterine sister. So uterine brother refers to your brother who you and him share a mother, and a uterine sister is again you and her share a mother, even though you do not share a father. A granddaughter, this refers to uh, your son's daughter, not your daughter's daughter. Your consanguine sister, your paternal grandfather, and your maternal grandmother. So this is, and sorry, consanguine means that you share a father and not a mother. So these are, and each one of them, they have their designated share, which we will go over a few examples in a moment, inshallah. The second is residuaries. There are three types of residuaries in the Sharia. The first is those in their own right. Number two is residuaries in another's right, and I will go over examples of this in a moment, inshallah. And number three are residuaries together with another heir. So residuaries in their own right, these are the individuals that are listed on your screen. Sorry, if we can move to the next slide if you haven't already done so. This is number one, son and grandson. So if these individuals are present, then what happens is, after the estate is distributed, if there is any percentage or any share left over, then it will be given to these individuals. Second is father and grandfather. So if the father is or the grandfather is present, depending on the circumstances, they are entitled to the remainder of the estate after the designated shares have been paid out. A brother, a real or real means is you share a mother and father. Consanguine means you share a father. Brother, son, real or consanguine means this is either your actual brother or a brother who your half brother, as we would call him in English, someone who you share a father with. This person's son is also residuary. Your uncle, real or consanguine, and your uncle's son. So these are residuaries. And mind you, the presence of any one of these doesn't guarantee them a share in their inheritance. The only people in this entire list that are guaranteed a share of your inheritance is your son and your father. So your son and your father are guaranteed a share of your inheritance. The rest of them, this is just entirely dependent upon who is present from the list of heirs. Residuaries in another's right. So these are those female relatives who are entitled to fixed shares but become residuaries when together with their brothers. So this is daughters, for example, are entitled to a fixed share. And however, they become residuaries when they are together with their brothers. And the way that the estate is shared over there is at a ratio of 2 to 1. That for every two shares that is given to the male child, one share will be given to his sister. And the reason for this, so a lot of people have this question that why is this the case? Why has the distribution occurred in this way? The simple answer to this is that the male heir has certain financial obligations and responsibilities that his female counterpart does not. So at no point would a daughter be required to contribute financially towards the maintenance of her household, even if she is married or if she is not married. Her money is her money in the eyes of the Sharia. However, her son, in the absence of his father, a son would be required to look after the household and maintain the household financially. If he is a husband, he is required to look after his family. And any male heir is at some, if not immediately, at some point in their life, is going to be financially responsible for someone else. And this is why the Sharia awards them a greater share of the inheritance, because this trickles down to the rest of the family and those that this person shoulders the responsibility for. Residuaries together with another, this is the next slide. Those women who are sharers, so who are named in that list of sharers, but are converted to residuaries in the presence of other female sharers. So the most common example of this is a real sister, when in the presence of the daughter, granddaughter, will become a residuary. So if there are no male children and the father is also not present, then what's going to happen over here is the sister in the presence of the daughter is going to become a residuary. So although she is actually a listed heir, she is named in the Quran, but because in this circumstance the daughter and the sister are both present and there is no male heir there, so they will be converted into these women in this the real sister in this circumstance will be converted into a residual heir. And by the way, if this is confusing, you don't actually need to remember all of this. I'm just going through all of this just to give you an idea of what we look at in terms of the distribution of the inheritance as per the laws of Allah subhanahu wa ta'ala. Otherwise, there are calculators even online that can give you a pretty good idea of who gets what in terms of your estate. And most people's estate planning is not nearly as complicated. So, for example, if you have children, especially if you have a son, then you don't even really need to worry about most of these things. And most people, they don't get this far in the list of distribution. Their situation is far simpler than this. So next slide, inshallah. This is an example of the deceased. So if somebody passes away and they leave behind a wife, daughter, mother, grandson, and maternal grandmother, right? So I'm not sure if can the brothers confirm if people can see this list on the screen over there?
Oh, yes, brother, we can see that.
Okay, so does anybody want to take a guess who gets what over here? Just so I know that you are paying attention and not falling asleep. So what we usually do, so although you can calculate this in percentages, the Quran calculates and distributes inheritance in terms of fractions. So not percentages, but fractions. So this is why we still calculate based on fractions. So naturally, when you are calculating based on fractions, the first thing that you will do, if you again, there are calculators to do this, but this is just for the sake of an example. The actual way that one would do this is the first thing is you would write beneath the actual just beneath the actual heirs, you would write their shares, which you can see on your screen. Then after that, you would see the lowest common denominator between these in order to distribute them. So in this case, it's 24. And then you would distribute these shares. So in this case, the wife gets 1/8, and the reason she gets 1/8 is because the deceased had children. The daughter gets 1/2, and the mother gets 1/6. The grandson over here is a residual heir, and the grandson means that this is the son's son. So this assumes that the deceased had a son who had passed away before him. And the maternal grandmother, although she does have a share in certain circumstances. In this circumstance, B stands for blocked, so she is blocked. She doesn't actually receive a share of the inheritance. So looking at this, in the total of 24 shares, the wife would receive 3, the daughter would receive 12, the mother would receive 4, and whatever is left behind, in this case 5, would be given to the grandson. So the reason I gave this example is there is a misconception that male heirs always receive more than female heirs. So in this particular circumstance, this is actually not the case. So if you look at the daughter and the grandson, the daughter receives half of the deceased estate. So in this case, 12 shares, and the grandson actually only receives 5. If we move to the next slide, so this is again the deceased who leaves behind a wife, a daughter, a mother, a father, and a paternal grandmother. So again, we would write their shares just beneath them. In this case, the wife gets 1/8 because she has children. The daughter gets half, again, just like the previous example. The mother gets 1/6. The father gets 1/6, plus he is also residual heir. So if there is anything left behind after giving everybody their shares, he would get that as well. And the paternal grandmother doesn't actually get anything in this circumstance. So again, lowest common denominator would be 24. And according to this, the wife would get 3 shares, the daughter 12. You don't have to remember all of this, by the way. The mother 4, and the father originally gets 4 shares, but the total of that would only equal 23. So there's 1 share left over that is again given to the father because he is a residuary. Moving on, these are just 2 other examples. In the top example, husband, 2 sons, daughter, and father. So we would write their shares beneath them. The lowest common denominator over here is 12. So the husband would get 3, the son and the daughter. So these are residual heirs. So the daughters are residuaries because they are together with their brothers over here. So the distribution is at a ratio of 2 to 1. So 5/6 are given to both sons, 2.8 each, and 1.4 for the daughter, and 2 shares for the father. And in the example beneath, the wife, the mother, and father, if these are the only 3 people that the deceased leaves behind, the wife gets 1/4 because she does not have children, so her share increases. The mother gets 1/3 of whatever is left over, and the father is the residual heir. So in this case, it's 3, 3, and 6. So the wife gets 3 shares, the mother gets 3 shares, and the father gets 6 shares. These two, the next slide, these 2 examples, and I chose examples intentionally that are quite common. So these, you can see that there is in both of these examples. In the top example, the husband gets 1/4, the daughter gets 2/3. There are two daughters, so each one of them gets 2/3. Um, sorry, the daughters together get 2/3. The brother and sister, they share in a ratio of 2 to 1, so 2 shares for the husband, 8 shares for the daughters, and combined, so they get 4 each. And the brother and sister, whatever is left behind, they will share in a ratio of 2 to 1. The husband, in this is the example beneath this. So again, we 1/4 to the husband, the son and the daughter are residuaries. The mother gets 1/6 and the father gets 1/6. The lowest common denominator here would be 12. So 3 for the husband, a ratio of 2 to 1 for the sons and the daughters and their share, and the mother and father each get 2 shares, right? So these are just some examples, right? And the reason I ran through that very quickly is that is actually the end of the slides that I wanted to show you. That's actually the easy part. So the easy part is just determining who gets what in terms of their shares of the estate. There are other things that need to be looked at when you are estate planning, both from a legal point of view, which Brother Saeed will talk about next, inshallah, but also from an Islamic point of view. And chief among them is actually your children. So if you have minor children, that you are leaving behind, minor children means that you are assuming here that both husband and wife pass away together. Right? So if either one of them passes away, then obviously the remaining spouse takes custody of these children. But if both of them were to pass away together in some unfortunate circumstance, in an accident or whatever, then who is going to take custody of the children? This is perhaps, this is even more important than who is going to get your money, right? So in terms of the Sharia, it is there is no hard and fast rule as to who needs to take custody of your children. Rather, we look at what is in the best interest of the children. So normally what this means is that the father's family usually is given preference in terms of custody, because they will have, it is assumed that this is their legacy, the legacy of their child, and that carries their lineage. So they will bear the financial responsibility of this. But in the real world, that's not always the case. Sometimes this is not the case. So you individually, you would look at what is the most suitable, most reasonable approach for you and your family. Sometimes this also means that, for example, if the father's family is ready and willing to take care of the children, but they don't live in the country, and the mother's family does live in the country, then it may be more suitable for these children to remain in the care of the mother's family, so they are not removed from the place that they grew up. So that there are a lot of variables here. There are a lot of things that need to be considered, and there are also legal things that need to be considered, which Brother Saeed will talk about, I believe, in his presentation. But whatever the case is, you need to inform these individuals of your wish that they take the custody of your children in the event that you and your spouse were both to pass away. There are some other legal documents that I won't talk about, that Brother Saeed can talk about in his presentation. These have to do with financial matters and the decision-making ability, either in your lifetime or if you were to pass away, that who is going to immediately look after your finances. And there are instruments that can be put in place depending on your own individual circumstances. And the last thing that and by the way, these are not actually like part of your will. These documents, they are just part of your estate plan. So in the event that you are unable to make your own financial decisions, who are going to make them, and what documents need to be in place in order for this to take effect, your lawyers can advise you on that. And depending on who you are and what your circumstances are, it's usually advisable that you have these in place as well. It's also, depending on your age, it may be advisable for you to have some sort of end of life directive as well. What this means is that in the event that there is the need to make a decision on your care towards the end of your life, whether or not to continue with care, usually this responsibility falls on the next of kin, and it is a tremendous responsibility for somebody to bear. And it's a lot easier if you make your wishes known in advance so that this person has something to work with. So this is, we commonly receive these questions at the masjid that, my father or my mother has had an accident and is on life support, and the doctors are saying one thing, and we are not sure what we should do. Should we continue this care? Should we not continue this care? And there's an entire discussion in the Sharia regarding passive and active euthanasia. This is assisted dying. So it's active euthanasia is never permissible. It's never permissible to administer a drug or any sort of it's not permissible to employ any mechanism to end someone's life actively, that you are actually the one administering this to end it. In certain circumstances, passively withdrawing care is permissible and may even be warranted. So if somebody, for example, is suffering from a terminal illness for which there is no cure, it is permissible to withdraw care. So if the doctors are telling you that all we can do for this person is perhaps keep them comfortable, and these circumstances are usually very difficult, and it's difficult to give like a blanket ruling for everybody. But generally, if they are saying that there's nothing else that they can do, then it is permissible at that point, based on the consultation of the doctors, to withdraw care under certain circumstances. Circumstances vary greatly on an individual case-by-case basis, so there is no like blanket ruling that we can give. But these instructions also may or may not be part of your estate plan. When you are talking about leaving this world, this includes all of the steps leading up to it. So depending on who you are. And the last thing, again, this is something that your lawyers can advise you on, but if you leave behind a substantial amount of wealth and your heirs include minor children, or sometimes they may not even be minor children, but they may be children who are adults, or who are, at least in the eyes of the Sharia, but they may not be mature enough to handle that amount of wealth if it were to be given to them, then it is permissible to employ the use of trusts, and the trust can be structured in various ways, which legal professionals can help you with. But basically, the idea of a trust is that this money that these children are entitled to is not given to them lump sum. Rather, there are various ways to structure a trust, but it's given to them gradually, so that I just want you to imagine for a moment that if an immature 20-year-old were suddenly to come into the possession of $1 million, right, that they inherited from their parents, then one can only imagine what this person would do with that money. Rather, if this person were, it is his money or her money, and they will get it eventually. But the way that you structure that payout, based on the structure of that trust, this is something that if this is part of your circumstances, then you need to seek legal counsel for, and your lawyers can advise you on to how to structure these trusts. And all of these things are things that go into estate planning. I usually tell people that the more wealth that Allah subhanahu wa ta'ala has blessed you with, the more attention you need to pay in this matter. And if Allah has blessed you with children, then it is of particular importance that you have a will in place, especially if you don't have a lot of family in the country. So your wishes with regards to your children need to be made very clear. And there are certain other legal things that need to be in place in terms of the executor of your will and whatnot, which I won't talk about today because today we do have a legal professional, Brother Saeed, with us, so he will talk about that, inshallah. And with this, I will conclude this part of the presentation. Jazakumullah khairan for your attention. If you and there is, I will share the link with Brother Ahmed, perhaps, of just a very basic inheritance calculator that you can view online, and you can just punch in, who is there in your family, and they will give you, a rough guideline of who gets what. But that only deals with wealth. It doesn't deal with these many other things that we talked about. And of course, I would recommend that based on your individual circumstances, if you are a practicing Muslim, then I would advise you to seek the counsel of a qualified scholar. So qualified is important because not all Muslim scholars are well versed in this particular area of Islamic law. So you want to find somebody who has some reasonable experience in terms of the practicalities of the laws of inheritance the Islamic laws of inheritance as they are applied in the West. And of course, after this, the Muslim scholar will not write your will for you. He's not capable of doing that. You will take whatever consultation that you have taken from him. You will take this to your lawyers, and they will write your will for you. And there are a number of excellent Muslim lawyers in the Muslim community that have a lot of experience writing wills that are Sharia compliant, and they would be more than happy to assist you. Jazakumullah khairan.
Jazakumullah khair, brother. Inshallah, just a little bit. Inshallah, just a little bit about our brother Saeed Akhtar. He practices in areas of residential and commercial real estate related transactions, preparations of wills, power of attorney, representation agreements, probating of estates, incorporation of companies, and handling of subsequent corporate procedures. And he also handles sale and purchase of businesses, personal injury claims, and all kinds of immigration matters. Prior to joining the Dominion Law Group, Brother Saeed practiced as a sole practitioner and has appeared at all levels of court, including provincial, Supreme Court, federal court, and the Immigration and Refugee Board. Brother Saeed was called to the bar of British Columbia in March 2012. He is fluent in English, Punjabi, Hindi, and Urdu, and he completed his Bachelor of Laws at the University of Karachi in 2010. Brother is dedicated to serving the community at large and spends a great deal of his time providing pro bono legal services to various individuals and organizations. He is down to earth, approachable, and takes pride in performing quality work in a cost-effective manner. Brother Saeed's interests include traveling, reading, and spending time with friends and family. His areas of expertise are conveyancing, wills and estates, Canadian immigration, personal injury, and corporate law. And inshallah, Brother Saeed, if the stage is yours. Jazakumullah khair.
Assalamu alaikum, brother. MashaAllah, Imam Yahya has covered everything. Nothing left for me, but anyway, first of all, my apology. I was supposed to come over there, but as I'm out of town, so I could not make it. Again, I'm not using computer, just my cell phone, so bear with me if something interrupts. Regarding will, as I discussed with Brother Mustafa, that I would like to share question and answer. I would like prefer, but anyway, as I could not make it. So some points I will discuss, and later on, feel free to discuss any questions if you have with me. And also I will share my cell number, and you can shoot me an email or you can call me for further individual basis. Uh, Regarding basics of will, I assume that everyone
Assalamu
knows.
alaikum, brother. If inshallah you could just take a step back. Jazakumullah khair.
I'm sorry.
The camera is a bit close to your face, brother.
As I said, I'm using cell phone, so maybe I will turn the camera off, so it would be maybe easy. So I will start from first slide. I will not go in detail. Later on, we will have uh, extended session for question answer. Then I will be pleased to answer your every question. I assume that you have basic knowledge of the will. Will is basically a legal document that outlines how a person's assets and possessions should be distributed after their death. Wills basically allow individuals to have control over their estate and ensure their wishes are followed. Regarding Islamic will, so it's totally allowable in Canadian law, under Canadian law. Only the thing is that we have to ensure that the will complies with the legal requirements under the Wills, Estate and the Succession Act. I'm on the next slide, benefits of having a will. So I have highlighted 3, 4, 5 points about distribution of assets and about benefits of will. Number one is distribution of assets. In this, as will specifies how assets will be distributed among beneficiaries. In will, you have detailed your wishes. You can, as Brother Imam Yahya discussed, you have mentioned, you can mention about all beneficiaries, how your assets will be distributed. Second thing is very important in the will, appointing a guardians. If you have minor children or you have disabled children, then it's very important to mention a guardian who will take care of your minor dependents. Third point is avoiding conflicts. If there is no, we will discuss later on, if there is no will, what will happen. So if there is a will, it avoids conflict between the beneficiaries because you have already mentioned in the will. Another important point is tax planning. When we say tax planning, so every individual has different situation. So some individual has a lot of, business or any assets. So if they do proper planning, they can create trust, and there are so other ways which they can utilize to minimize the taxes. And finally, peace of mind. If you have will, then you have peace of mind. It gives you assurance that your wishes will be carried out after your death. Now, what are the legal requirements for a valid will in BC? Most importantly, there is testator's capacity. The person who is making will must be sound mind and at least 16-year-old. Although age of maturity in BC is 19 year, but any person who is 16-year-old, he can make a will. And second one is its intention. He can clearly express the intention to create a will. If he is not sound-minded, he cannot clearly express intention, then he cannot eligible to make will. That's why when someone has dementia or problem with his mind in old age or in hospital, so then we have to get expert views from doctors that whether he can clearly express his intention or not. Third one is witnesses. That's most important. The will is valid only if there are two witnesses in the presence of whom the will maker has signed and both were present and they will sign at the same time. All beneficiaries and spouses, they cannot be witnesses. And last is signing and dating. Will must be signed and dated. All witnesses and will maker will sign at the same time and put the date. Another important part in the will is, first of all, the will maker has to uh, make his wishes that how he will distribute the assets, and also he has to choose a person which is called executor. That person would be responsible to distribute the estate as per according to the will maker's wishes. Executor's responsibilities are, first of all, administer the will, administering the estate, whatever is left, whichever is estate, and according to wishes of the will maker. And he is also responsible to gather and protect the assets. He has to pay the debts, taxes, expenses of the state, as Brother Imam Yahya has mentioned already, that first of all, he has to pay all the debts, taxes, and expenses. After that, he will distribute them estate to the beneficiaries according to the will. Another important role of executor is probating the will. So every will doesn't need to be probate. There are so many factors which we have to consider. For example, if the will maker has a real property or bank account, only those are the assets, and those are jointly held with any other person. I mean, joint account or property is under joint and tenancy. So then he doesn't need to be, the will doesn't need to be probated. But if the property is not jointly held, or bank account is not joint, and also there are some more assets, then it must be probated. Probate means that executor will take the will to the court, Supreme Court, and court will verify that this is valid will and all the assets should be distributed according to the will. And another role of executor is to handle all legal and financial matters. Sometimes there are disputes and there is litigation, so it's executor's responsibility to take care of those. So while choosing an executor, the will maker, there are some, consideration which is will maker should consider. First of all, he should consider that the executor should be some responsible person, mature person, trustworthy, and he is capable of fulfilling the duties. And also, it is advisable that there should be an alternate executor, appointing a backup executor in case the primary executor is unable or unwilling to serve. And sometimes you can make more than one executor. I mean, giant executor, not alternate. Alternate is different, giant is different. You can make giant executor, two executor together, or three executor together, and then they can make decision jointly. Next slide is about distribution of assets. Key points to consider regarding the distribution of assets are, first of all, the will The will is the guide that will provide how will clearly states how you want your assets to be distributed and to whom you want to give. Second one is specific gifts of bequest. So sometime will maker give some gift to any beneficiary, or even if it is if he or she is not beneficiary, he wants to gift something, or he want to donate to charity organization, then he will mention in the will. So executor job is first of all to pay debt and taxes. After that, while distribution, first of all, he will distribute those gift or donation. After that, whatever is remaining, that will be distributed. After pay, distributing gift, the estate which is left, that is called residual estate. The remaining assets known as a residual estate are distributed according to the terms of will. Whatever is written in the will, it will be distributed accordingly. Some people, actually most people, they choose to distribute their estate equally among their beneficiaries, such as equal to all children or siblings. But some individuals may opt for a proportional distribution. For example, you may allocate 50% of the estate to one child and 25% to two other children, or maybe one share to boy and half share to girls, according to Islamic law, or whatever you want to wish, you can do in proportionally. Achha. Another thing is that there are some contingent beneficiaries. Contingent beneficiaries are um, those, um, for example, there is one beneficiary, brother or child, who died before the will maker, who predeceases the will maker. Then what will happen to grandchildren or whatever beneficiaries are left of the child? That will define in the will. Your will should specify how assets will be distributed if named beneficiary is no longer alive. And another tool is trust and other estate planning tool, which we already discussed, that it's very important while making will, that will maker should consider whether there is a need for a trust or no need. If there is a need for trust, if there is complicated assets, then it is advisable to create a trust, for, especially for minors and other disabled dependents. Again, as brothers Imam Yahya discussed, that it is always advisable to get professional advice. Some, not all, but some few important consideration of estate planning I will discuss. For example, blended families. When there is complexity of distributing assets among spouses, for example, person has two spouses. Even in this Canadian society, I'm not talking about Islamic, even Canadian society, some people have wives, they divorced and they have common law relationship, but law allows those spouses also to get their shares. So those are called blended families, and sometimes stepchildren and previous relationship. So if there is blended families, so then estate planning consideration must be taken place. Some dependents with special needs. Again, same, there must be a trust for special need person. So the will maker should make sure that guardian is appointed and trusted created just for their easiness. If they are giving charitable giving, they can donate some portion, or even they can create a trust for charity. They can establish their own charitable foundation and they can allocate to certain portion of their estate. Okay, the most important thing which I observed in my practice, business succession. If someone has a business and he does not do any good estate planning or does not make will, there are lot of complication to his successors, beneficiaries. Especially, they cannot continue business without smooth transfer. There are a lot of disputes, and again, complication of ownership and management of the companies and business. So it must be taken care of. Okay, so as you know, the will is almost forever. Once you make will, if you don't revoke or update, this will continue until your death. So it's always advisable that when there are certain changes in your life, for example, another marriage, divorce, or new birth, adoption, or death of any beneficiary, it's advisable to update your will. Or you want to revoke and prepare another will. Or if you want to change some beneficiaries' portions, you can again update and revoke a will, or just simply update. If there is minor updating, then only one page is sufficient. That page again must be witnessed by two persons and you can attach to the will. But if there are major changes, then you have to do new will. When you do new will, then the previous will be revoked. It's very important because there cannot be two wills or three wills. There must be only one will. Again, some assets or liabilities, or if there is changes in assets, debts, or financial circumstances, you can amend your will or you can write a new will. Or sometimes there are changes in laws, then again, it's advisable to update your will. Okay, there are some assets which are not part of a state. Those assets, if you mention in your will, if you don't mention, it makes no difference. Those we advise that because it will be contradiction. So it's a good idea not to mention in the will because those assets are not, does not, especially these assets do not become part of a state. For example, insurance, life insurance, RRSP, TFSA, pensions, the assets which are registered jointly, those uh, those are not part of a state. So usually those life insurance, RRSP, pension, and TFSA, you have already mentioned beneficiaries while you get that. So that will be effective. As we discussed about guardianship of minor children, it is very important because it ensures the care and well-being of your children according to your wishes. It provides peace of mind knowing that a trusted individual will assume responsibility for your children. It also allows you to choose someone who shares your values, beliefs, and parenting style that we will discuss in the next slide, inshallah. While choosing guardian, some factors you should keep in mind that the person who will be guardian, first of all, he will be stable person and he has a relationship, he has with the children or yourself. So he will, that's uh, that will be helpful for the children and benefit. Also, we should keep in mind that person should be matured and he should have some parenting skills. If we put a guardian, just a 16 or 18-year boy, 19-year boy who has no experience, so maybe there will be complication. Again, geographic proximity. It is recommended always that the guardian should be from the same city or at least from the same province or country. Most of my clients or my friends, they say that they want to nominate guardian for their children who lives in Saudi Arabia or Pakistan. So I always advise that consider that someone should be from Canada, from this say your city or from this country. If you cannot find any trustworthy, so at least you can do, you can nominate giant guardians, one from the city or country and one from out of country. So at least when something happen, the person who is foreigner, he cannot come immediately. So the person who over here, he can consult him over the phone or whatever media and he can take actions. Also, it's advisable to consider financial capacity of the guardian. And the other part, alternate guardians, joint guardian or alternate guardians, both are recommended. I mean, alternate guardian means if someone is not available or he does not want to do that duty, so the alternate guardian will take over. And again, communication and consent is very important. Before nominating guardian, first of all, talk to him or her, whether he is able and he is willing to do this. If he is willing, then you can nominate. Um, as we mentioned above, first points, relationship. So relationship, siblings, if siblings are mature, then those are the best options. Again, like will, after a few times, you should review and update about guardianship, whether you want to change it or maybe minor children become mature, you don't need guardianship. Uh, I've written some consequences of not designating a guardian. It's understood, but anyway, if there is no guardian, then court may have to decide who will assume guardianship of your children. The court decision may not align with your preferences or what you would have wanted for your children. The decision-making process may involve input from various parties, leading to delays and uncertainty. Yeah, that's understandable. No, that's the big question which Brother Mustafa has asked. If there is no valid will, then what will happen? Okay, the rules in BC says that if there is no will, and there are so many conditions, but I have given some just 4 examples. For example, if there is spouse and children, then according to law, the estate is divided between spouse and the children. But if there is spouse and no children, then spouse will get entire estate. And if there is no spouse or no children, then estate passes to other relatives according to a set order determined by law. I didn't mention any detail, but again, brother, sister, parents, there is certain law and it will be disputed according to that law. Sometimes there are two or more spouses and they have conferred. If they uh, usually, I observed that if there are more spouses, especially in Western society and Canadian society, they know somewhat law and they do agree for distribution. But if some cases, if they do not agree, then the court will interfere and it will decide. And there are a lot of complications. The court have to consider that who have spent more time with the will maker and who have. There's a lot of things to be considered. But again, the main point is that if there is no valid will, that then your wishes will be lost and everything will be distributed according to the law. So even your beneficiary may not get as you want to give them. And I highlighted a couple of points. for not having will consequences. Number one, distribution of assets default rules. As I mentioned, if there is no will, then according to law, it will be distributed. Potential disputes among family members. So if you have a will, you have already given your wishes, then your beneficiaries, most probably they will not dispute. They say, okay, our dad has, it's his wish, so we have to obey it. But if there is no will, then there would be dispute among the family members. Someone say, "Oh, I should get more. I was obedient servant, obedient, sorry, obedient wife to my father, and father has spent a lot of money on the other siblings during his lifetime. So there are chances that there will be dispute. And again, there will be no control over guardianships. And one point which I missed, came over here, when there is no guardianship and there is no will, then for minor and disabled dependents, public guardian and trustee will be involved. It's not court, it's another department that will take over. And that will take over of those minor children and disabled person. So it's a bit complicated. And again, there is no will and all the process will be delayed. If the will was, if there are a lot of assets and if there is a will, then the executor has to probate it. But if there is no will, then again they have to court. But that is called grant of the administration. That is a lengthy process also. It's just like probate, but it's called grant of administration. And 6 point is unattended beneficiaries. Oh, it means that, for example, some beneficiaries you don't want to give them, but if there is no will, then they will come up and they will get it. Business succession challenges, which we already discussed, and you cannot manage your business or there will be complication. If there is will, you can make smooth transition or smooth transfer of business to new management or ownership. Inefficient asset distribution, of course, and there would be high cost. What would be involved? Public guardian trustee will be involved, and those are not free. They will charge their fees, and also there may be some tax consequences. If there is will, you can do proper estate planning, create trust, and save some taxes. So tax consequences dying without a will. So good thing is there are two taxes, estate tax and inheritance tax. They are not, there is no estate tax, no inheritance tax in BC. Only federal tax. Federal tax is only if, I can give you example, if beneficiary gets property at any part of a state, that part will be considered, its value will be considered at the time of death. But that beneficiary will get that property or that estate not immediately at the time of that. Maybe later on after probate or whatever process is, maybe it takes 6 months, 1 year, 2 years. During that period, if the property or asset gains its value, then for that value, he has to pay tax. That is only federal part. In BC, there is no tax. Capital gain tax, again, they have to pay it. Income tax. Income tax, if the property is, making money, for example, rental property or business, then up to death, whatever they had made, there is no tax. But after that, after death, if it's making money, generating money, for rental or investment from investment, then there will be tax. Tax inefficiencies. Again, we have discussed that without a will, the state may not take advantage of tax planning strategies, for example, trusts and other exemptions. So I want to mention two more documents which are not part of will, but they are part of a state planning. Those are called power of attorney and representation agreement. Power of attorney. There are two kinds of power of attorney. One is simple power of attorney. Simple power of attorney means, for example, you want to authorize someone to do some specific work. Okay, uh, deal this rental property just one time, or to sell the property, you are out of country, or whatever reason. That's specific, only specific work. That is called simple power of attorney. But mostly used is enduring power of attorney. So different between both are, I mean, representation agreement and enduring power of attorney, both are called power of attorney. But the main difference is in enduring power of attorney, you can appoint someone who can deal with legal and financial matters on your behalf. On the other hand, in representation agreement, which is similar to that power of attorney, but it allows only to appoint you to appoint someone to deal with medical and healthcare matters. So that's the main difference. Legal and financial matters, enduring power of attorney. Medical, healthcare matters, and personal matters, that is representation agreement. One thing we should keep in mind that power of attorney is valid only until the time of death. Once the person is passed away, those power of attorneys are ineffective. They're gone. And will starts from that point. So I know I'm not a good speaker, but anyway, I try my best. But the main thing is, if you have any question, I will be happy to answer. Please go ahead. And one more thing, I don't know whether I have mentioned in slides or not. Brother Ahmed, please write down my cell number and you can pass on, feel free. Any person who is not comfortable to discuss over here any confidential matter, he can call me and I will be happy to answer the questions. Jazakallah khair. Brother Ahmed.
Yes, Assalamu alaikum. We are just checking if there are any questions. So, brother, the question is regarding joint mortgages for houses and that they, or even bank account, that they are bypassed. How would that be written in an Islamic will?
Oh, Islamic will. Islamic will, it would be written that all the properties, real properties, first of all, okay, there are two portions. Number one is that all the debt will be paid before distribution of the property. But the property would be transferred to the beneficiaries, including the mortgage. And that beneficiary would be responsible to pay that mortgage. Okay, the bank, if they, I'm talking about the practical situation, if the bank come to know that person has passed away, they will or they may ask to pay the whole money. But if they don't, if you are paying mortgage regularly, the beneficiary is paying mortgage regularly, then usually the bank don't care. And if, for example, if there are 2, 3 beneficiaries and they want to distribute that property, so what will happen? It's up. It's sometimes they put in the will. Okay, you cannot sell the house. It will remain under this under this child possession until he gets age of this one or whatever. But if there is beneficiary says that no, we want share from the house, then what will they will do? They will list the property and sell the property. First of all, they will pay the mortgage, and remaining portion they will distribute among themselves. But in will, the will maker should mention that, I mean, there are 2 options. If they mention that property will be distributed among the beneficiaries, that's it. It's up to beneficiaries whether they want to hold the property or they immediately want to sell and distribute. But if will maker says, no, this property will be sold at that point. For example, their mother will live there until she is alive. They cannot sell the property. Until the youngest son is married, they cannot sell the property. I mean, whatever condition the will maker put, it will be part of the will.
The brother is asking for a simple Islamic will, how much does it cost?
Oh, I'll talk about myself, whatever I charge. Usually we charge $600. But for this community, I will charge 500. Again, if they donate $50 to the mosque and I will donate $50, then I will charge $400. Does it make sense?
Yes, it does. Any other question?
Is the Imam still?
Yes, yeah.
Okay. I've got 2 different questions.
Yeah.
One question is, if you have assets and wealth, does the Sharia say anything about, let's say you've got 2 sons, 50-50, they each get 50-50. Can you say you get the assets, you get the wealth, or does it have to be 50 assets, 50 wealth?
Brother, do you understand the question?
Yes. So in terms of that question, you can say that, you can designate. So when you say assets and wealth, we treat anything of value as assets. So did you want to elaborate what you mean by assets?
Someone had a bank, exactly that. Someone has a house and they have money in the bank, exact same amount as the value of the house.
So as long as there are 2 things here. So technically, the way that that the Sharia entitles the both sons to their share is they actually are entitled to 50% of each. So if the deceased willingly, and again, this is not from the legal point of view, this is strictly from the Sharia point of view, that if the deceased names some specific asset for someone, let's say, for example, there is the value of the home and the value of the bank account is equal. So hypothetically, and the deceased says that you will get everything that is in the bank and you will get the whole house. This is permissible to do. However, if the sons, they dispute this, right? If they say that no, if they are happy with it, that's fine. We don't. There's nothing wrong with that. But if, let's say, the one who got the house or the one who got the money says that no, I don't want just the money, I want a share of the home as well, then from the point of view of the Sharia, he is entitled to make this demand. I don't know what type of legal implications that would have, but at least from the point of view of the Sharia, this is a valid demand that he would make.
Yeah.
Let's say you talk to the son, ask them, so if you talk to the son, ask who wants the house, who has the bank, you sort it out ahead of time, so there's no problem. Then in the Sharia, that's okay, as long as the values, each person gets it the same.
That's right, yes.
Okay.
So technically, when you are still alive, you can do whatever you want with your money. So like if you are, a lot of actually elders, they do this in the community, that for one reason or another, if they are, if they are fearful that, there may be disputes after their death or something like this, they actually distribute their property and their assets, especially if they have a significant net worth. They do this in their lifetime. And while you are still alive, you can actually do whatever you want with your money. So you can give more to one, less to another. It's as long as your children are not minors. If they are minors, the Sharia requires you to be exactly just with them. But if they are not minors, if they are adults, then sometimes you have, for example, let's say somebody has 4 or 5 children, and 3 of them are well off and 2 of them are not. So they may wish during their lifetime that we want to help these 2 out by giving them one of our rental properties, or by giving them this, or by giving them that. That is permissible. There is nothing wrong with that.
Tax implications. So again, scenario, I have 2 sons. One lives in Canada, one lives in another country, and in that country, there will be some kind of estate tax when I send the money. Do I need to account for that when I'm making the will, and then maybe set that aside inside of the wasiya?
No, so you are not required to account for external factors from the Sharia point of view, right? So, like, external factors means things like, this the tax. So, like, if that estate is going to be taxed in a particular country and it's not going to be taxed somewhere else, then that's not, it's not your job to account for that. Your job is just to distribute it according to the laws of the Sharia. If it is possible for you to plan effectively for tax purposes, the Sharia has nothing against tax planning. So if you can structure your distribution in a way that is tax effective, then there is no problem with that. But as far as responsibility is concerned, the Sharia does not hold you responsible for doing this. So if your responsibility is simply to follow the laws of Allah, but again, as if you do this and if you make sure that it is effective for everybody, as long as you are not taking anybody's right away, there is nothing wrong with that.
Any other questions? There's a question sent directly to you, Imam Yahya.
Directly to me, where?
On the one.
Did you send me a
Brother
message?
Ahmed has sent you a question on WhatsApp.
Okay. So this is the question is, if a beneficiary or beneficiaries receive a property from the deceased who is still paying off a mortgage, and the beneficiaries do not deal with interest, would they be forced into paying the rest of the mortgage? Is there a sin upon the beneficiary in doing so? So, from a legal point of view, yes, you would have to pay off the rest of the mortgage, as is kind of obvious. There is, and the second is, would you be sinful for doing this? No, you wouldn't be sinful for doing this, even if, regardless of what your views on mortgages and interest are. But even if you are of the you do not deal with interest at all, but you inherit a property that has an interest bearing loan on it that you need to pay off, then that is not, this is a transaction of necessity, that in order to free your estate, and that does not carry the same ruling as willingly entering into the contract. So inshallah, we wouldn't regard you as sinful for that.
And following up on the other question, you said that in the life you can give one son more than the other, or any of the inheritors. Can we just make a wish or make it known, but that it would be executed at the time of death? Does the
No.
study allow that? Or it has to be executed in the life?
No, so as soon as you die, as soon as you close your eyes, your money is not yours anymore. There are laws that Allah has put in place that need to be followed. So if you want to distribute in any way that you please, that needs to actually happen during your lifetime. It cannot be, and it has to take effect during your lifetime. You cannot leave it until after death, right? So usually it's elders that do this. So those who are, um, who are seniors, who Allah has given them a long life, they have wealth, they have assets, and many of them, they choose to distribute this during their lifetime. So that is permissible, and it is not a requirement to follow the exact distribution laws of inheritance, because this is actually not inheritance. This is a gift that you are giving during your lifetime. The tax implications of that's something that you would have to discuss with your lawyers and accountants, but from the Sharia, it is permissible.
Yes. If you form a trust for your children, two questions. How do you determine the distribution within the trust, and how long can you have the trust be paid?
So in structuring a trust, the only thing that you need to make sure of is that you are not depriving somebody of their right. So in effect, what this means, that eventually whatever is due to each heir needs to reach them. Now, it is up to you to determine how and when that is suitable, right? So, I'm not an expert in trusts, but, Brother Saeed is here. Usually what this entails is that there is a gradual payout of that trust over a number of years. There are a number of payments that are made, either quarterly, monthly, whatever, and somebody is actually looking after that trust as well. And then there comes a certain cut-off date, and this is optional, that at this date, or when the recipient reaches this age, then you can pay off the remainder of this trust to them. So again, it's usually for children that people do this. So not necessarily even minor children. So like I said, that I actually had a case where there was a father who had passed away, somebody with a significant net worth, and each son actually received a $2.3 million in terms of their inheritance. And these boys, they were twins. They were 22 years old. So you can only imagine what a 22-year-old boy would do with $2.3 million, right? So the mother was here, she was complaining, but at that point it was done. There was nothing that could be done to remedy that situation. But this is something that you know your children the best. You know their maturity level. You know what kind of spending habits they have. You know these sorts of things, so you can determine what is the best course of action for you. Also, tax-wise, what may be the best course of action for you. So as long as the condition is, as long as nobody is receiving less than they are entitled to, it is permissible to structure that trust in any way that you see fit.
Brother Saeed, yeah, I just wanted
Yes,
to ask.
please.
So you said that the RRSP and TFSA and other accounts will not be part of the will. So what does that mean? Can you please elaborate on that?
Because when you open RSP or TFSA or such kind of life insurance, and then you um, give your beneficiary name to the bank or whatever the situation is. So that your consent for that beneficiary supersedes your will. Even you mention in your will, for example, if you open RRSP in the bank and you put that your beneficiary would be, our next of kin would be your wife. And if you make a will and you mention in will that for RRSP is in part, will become part of your estate and it will be disputed among your children. So it's mean that will is contradicting that part which you have already mentioned, that your beneficiary would be your spouse. So that will supersede your will. That will be accepted.
On that question, is there a chance where we can give a certain distribution in terms of percentage for the sake of beneficiary in
Oh,
the TFSA and RRSPs?
yeah, you can mention it. When you open your TFSA at that time, you can mention. Or if you, sometimes TFSA, I'm not sure. I think for TFSA, it's not mandatory to mention beneficiary. For RRSP, for life insurance, is mandatory. For TFSA, if in the bank you mention your beneficiary, it's okay. If you don't mention, then you can mention in the will that, okay, this will become part of my will. Or even in the will, there are a lot of assets. For example, one is TFSA, one is a bank account, one is property. You can mention in the will that this property, this bank account, this will become part of a state, will be distributed among the beneficiaries equally or whatever. But that portion, which TFSA or whatever is left, for example, jewelry, you can say, okay, no, this will go to those beneficiaries, not to all beneficiaries. Whatever wishes you have, you can put in your will.
Jazakallah khair.
So one last anonymous question for Imam Yahya. Is the distribution of wealth according to Sharia applicable to non-Muslim children as well, or must they be Muslim?
So one of the rules in the Sharia, or one of the so there are, especially when so one of there are in the books of fiqh, there is the discussion of mawani'ul irth. So mawani'ul irth are depriving factors, right? So what are the factors that may deprive someone of their share of the inheritance? So there are a number of things, and one of those things, so for example, I believe this may be similar in certain civil laws as well, that if the heir kills the deceased, if there is this sort of an action that takes place, this deprives the heir of their share of the inheritance, and the difference in deen is actually one of those as well. So what this means is that a non-Muslim child does not inherit from Muslim parents. Um, However, given that, as Brother Saeed can elaborate, in BC there are two classes of individuals that have the right to challenge your will. One of them is actually your children. So the civil law does not actually look at your this reason. So this is why, if this is the case for you individually, then what needs to happen is you need to make your lawyers aware of why you don't want such and such a child to inherit from you, and they need to put this in a written explanation inside your will, so that if this child challenges your will in court, which they legally they have a right to do, then again, it's still not guaranteed that the judge will honor your wishes, because in BC the judges, they have what we call corrective powers, right? So corrective powers means that if the judge deems that your distribution is unjust, you have deprived someone, then the judge will correct it. There was a very high profile case a couple of years ago in the Sikh community where the daughter was given far less than the sons, and she took her father's estate to court, and she actually won equal distribution, and this was the judge used her corrective powers to correct the father's will. So this is possible, but if that does happen, then it's not, your responsibility has been fulfilled. You have done your job as per the laws of Allah, and that's it's no longer your responsibility. But this is just that your lawyers will be able to put this explanation inside. So if you are depriving somebody, then you need to explain why. That why is it that such and such. And people do this all the time. Even non-Muslims do this. That I don't want to give like my second son anything from the inheritance, and that the reason mentioned in the will is he was very rude to me, or he didn't live with me, or he didn't call me, or he didn't do this or that, or whatever he didn't do, right? But the explanation needs to be there for in case it is challenged, for the judge to see, and the judge will decide then after that. And sorry, one other thing that I will mention there is, although they don't inherit from you, it is still permissible to make a wasiyah for them. So,
so clarification for the what you said for the father when he distribute the money, where the children, some of them financially good and other financially is not good. What happened if one of the children or few of the children, they are not happy from the father when he's alive to give some money for those, financially they are not good. Because here the problem here is, that is, if he maybe has the right to do that, it's money when he's alive. But the problem here is it's a corrupt the relation between the children, because you are giving some people, but while the other guys are not happy for this money, and also it's not fair. There is no adl in distribution. So it's a big issue because you spoil the relation between the children even after you die, after the person is done.
Yes, so that is true. So you would have to do this based on your own individual circumstances. And I usually recommend to people that if you intend to do this, then don't keep it a secret. Make this known why you are doing what. Usually, what children are more upset with is that they are not told this, that the father gave such and such an amount to so and so during his life. So the children are still thinking that the father still owns this property, and only after he dies they come to know that no, he doesn't actually own it, because 15 years ago he gave it to someone else, right? So that's usually where this issue arises. But again, you are right that this may cause some ill feelings between the children. That's up to you, for you to decide, for you to maneuver. I am strictly just speaking about the permissibility of doing this, and the practicality of it. That is for you to determine.
Islamic organization. Jazakallah khair, Sheikh. I don't know if you can hear me.
Yes, I can.
Okay, Jazakallah khair. So the most important thing here, we have talked for a long time. Say there is a brother who is married to a non-Muslim, and we advise him in your will, get your will and state your intention to be buried, inshallah, may Allah give you all long lives, to be buried in Islamic manner. As an organization, how much, or they say, backing, like legal, flexibility. Do we have a right to interfere and says, no, this is his will, and his will became known and says, yeah, this is his wishes, and therefore we can interfere and take over?
It's actually not a matter of right or not, because you live in Canada. So we regard it as an individual responsibility for a practicing Muslim to distribute their own estate according to the laws of the Sharia. If somebody does it otherwise, then realistically, there's nothing that you can actually do about this. So it's not really something that even if you wanted to, you couldn't possibly intervene. You can advise him, but otherwise, legally, if legally your brother, your siblings are not one of the two classes of individuals that can that have an automatic right to challenge the will. So you would first have to, and Brother Saeed can speak to this, but you would first have to actually prove to the court why you should be entitled to challenge it. You don't have an automatic right to do this, right? So this is,
I believe the question was regarding to that if a person's spouse is non-Muslim and the person puts in their will to be buried Islamically, and the spouse has other wishes, what rights do like us as a Islamic organization have to enforce that no, this is his will, he must be buried Islamically?
Good question. So that is actually up to the executor of the estate. Is the person who is responsible for looking after this person's will, right? Including this person's burial wishes. So this person, if this is the case, especially if you fear that this could be the case, then I would recommend that you speak to your lawyer and you have them draft this in writing as a separate document that is filed with in BC, the BC Muslim Association, so that when this person passes away, this eliminates this legal hurdle. This has happened in the past, where this the family, the non-Muslim spouse wants to bury the Muslim man according to her wishes, but he has left other instructions behind. And I remember at one point there was actually a delay of about 3 weeks for the janazah. For this specific reason, but because he did leave written instructions behind and the executor was aware of this and the lawyers were aware of this, we did end up burying him according to the Islamic way. But unfortunately, there was about a 3-week delay in this due to the ongoing legal challenge that the spouse had started.
One thing I would like to mention is,
Okay, Jazakumullah khair. Inshallah, today that is all we have the time for. Again, if there are any more questions, you can further it to us. And inshallah, we can then further it to Imam Yahya, Momla, and Brother Saeed Akhtar. Jazakumullah khair. And then inshallah, we have refreshments available in the back. Jazakumullah khair. Assalamu alaikum.
Assalamu alaikum.